everyone. Thank you for joining us today for a panel discussion on civil protection orders and remote hearings. My name is Stephanie Bowman, and I'm a program attorney with the National Council of Juvenile and Family Court Judges, and I work on our civil protection order project. The NCJFCJ Civil Protection Order Project, with funding from the Office on Violence Against Women, focuses on improving civil protection order process through systems-focused multidisciplinary training and technical assistance, especially around emerging issues in the protection order realm. Speaking of emerging issues on the protection order realm, we have a wonderful set of panelists today that have joined us to talk about their use of remote hearings, especially as a response to COVID-19 and the needs of the community to have access to this important judicial remedy. Joining me today on this panel, we have Chief Magistrate Judge Beryl Anderson from DeKalb Magistrate Court, Decatur, Georgia, Administrative Judge Carol Kelly from the 11th Judicial Circuit of Florida in Miami, Florida, Chief Unified Family Court Judge Janet Hilson from King County Superior Court, Seattle, Washington, Stacey Mars, Administrative Director for the Alaska Court System, and Amy Hernandez, Domestic Violence Program Coordinator and Justice Project Coordinator, Utah Administrative Office of the Court. Also with me today are my colleagues Nancy Hart, who will be trying to keep us on track time-wise to make sure we can cover as much material as possible, as well as Jennifer Arsenian and Amanda Kay, who will be monitoring your questions in the chat box, so please feel free to type any questions you have for the panelists in the chat box on your screen. Our outline for today's discussion will be as follows. We'll start with specifics about different types of hearings, including temporary emergency ex parte hearings. We'll move into final evidentiary hearings and end with order compliance of order order compliance monitoring. Sorry about that. We will also then discuss remote hearings, domestic violence, and access to justice issues as a group, as well as lessons learned in the future of remote hearings for these jurisdictions. For time's sake, we will rotate which panelist speaks first for this segment and then ask other panelists to share how their practices may differ before moving on to the next segment. So let's begin with Judge Anderson. Thank you, Judge, for being here. Can you tell me, did your court already have a remote hearing system or policy in place before the pandemic?
Stephanie, thank you for the opportunity to share with you all this afternoon. No, our court did not have a remote hearing system in place for protective orders. We had a remote Zoom system in place for some of our criminal proceedings, and so it made it very easy for us to, well, I won't say easy, it made it a little easier for us to transition to that process during this judicial state of emergency.
So, Judge Anderson, how are you holding temporary or emergency ex parte hearings?
So the hearings are being conducted remotely via Zoom. I think it's important to back up and be clear that our Chief Justice of the Supreme Court issued an order for an emergency on March 14th. On March 23rd, our clerk of court, who handles all of the petitions and handles all of the filings, decided to operate her office virtually. And so when that happened, it really threw our court into trying to be as creative as possible and work as swiftly as possible to make sure that victims of family violence and stalking in DeKalb County were able to get protective orders. And while handling those matters remotely had been something that was on my wish list, it moved during this emergency from my wish list to something that we had to get done. And so in a very short period of time, about 3 days, and after collaboration with many stakeholders, with our sheriff's office, our clerk's office, our IT people, we were able to get up and running with Zoom. Safety was at the forefront of everything and continues to be at the forefront of everything that we do. So this process would not have been possible without our advocates assisting us on the front end of this process.
Thank you. You answered. Go ahead.
Do you want me to share with you what that process looks like from a petitioner standpoint?
Yes, please.
Okay, so someone who finds themselves a victim of family violence or stalking who would like to contact the court for obtaining a protective order or applying for a protective order, they will go online virtually to our clerk of court's office. At the outset, it says that if you are in danger, please dial 911. And there are online instructions for completing the protective order application remotely. Number one on the list is again, because safety is paramount, number one on that list is to ask them to contact a culturally appropriate advocacy agency. And here in DeKalb, it's either the Women's Resource Center for all English-speaking petitioners and Tapestry for non-English-speaking victims. And so they contact them for guidance and assistance in completing the application process. We know that that some victims are not as technologically savvy as others, and so they do get a tremendous amount of guidance through that process and get a lot of questions answered on the front end by having advocates assist them with the application process and with safety planning. In addition, they're able to upload any documentation or that they want to submit with their application, and they are literally walked through that process by the advocates.
How does if they wanted to submit other documentation remotely, how does that work?
So if they want to submit information remotely, let's just say that they submit something like the police report with their initial petition. That information is sent to the judge. The judge gets notice that there is an application that's waiting. The judge will reach out to the petitioner to let them know that they will be calling them for a hearing and for them to stand by for the hearing. If the petitioner realizes that there's additional information or evidence that needs to be submitted for the judge to consider, then they can do that either through a shared screen function on Zoom, or they can email one of our clerks ahead of time, who will in turn send that information to the judge for the judge to consider through that Zoom hearing.
Great, thank you. You've mentioned some of the challenges, but are there any other challenges that you think you should mention about establishing this process?
Yeah, I will always go back to safety. That is always something that we're considering throughout the process, and we're continuing to look at this and figure out how we can make this process better. But it was one of the challenges is to make sure that we're not doing anything to put victims in harm's way. And so from the very beginning, they're told that when they're before completing the application, that your safety may be compromised if someone has access to either your telephone or your email. And so if at any time that becomes an issue, then they should not pursue this, but instead they should reach out to an advocacy agency and perhaps complete this process at another time. Another challenge is we posted that on our website. It's on the clerk's application process. We want to make sure that victims get that message. Another challenge is making sure that petitioners are clear that just submitting the application does not mean that you have a protective order. There is a second step. You have to have that hearing, and at the conclusion of that hearing, the judge will tell you whether or not you have an order, and then you'll be given additional steps about how to get a copy of that order. Since we're doing it remotely, petitioners are getting a copy of their ex parte order either they're getting that electronically as well, and so they have a copy of it in their phone or on their computer. And I think those are the top challenges that we've had. And I think we have to, if we take our eye off safety, then we may be creating a problem if we ever take our eyes off the safety factor.
Thank you, Judge. We do have one question that's coming for you. If they do share their screen function, how does it get into the record so it can be served? So say share the additional evidence or documentation with a share screen function.
How is it getting into?
How is it becoming part of the record to be served?
Well, the evidence is not going to be served with the petition. If the judge conducts a hearing and grants that 30-day ex parte order, it will just be an order. There will have some very specific instructions in the judge's order, and specifically who should be, if it's an eviction, who will be removed from the home, whether or not firearms are to be seized, if custody is involved. Those are very clearly delineated in the actual order, but we do not attach any type of evidence to the ex parte order.
Okay, thank you.
Okay.
Now moving on, Judge Kelly, thank you for joining us as well. Is there anything you'd like to share about your temporary ex parte hearing?
Hi, well, thanks, Stephanie, and thanks for putting this on. Very happy to be here today with everybody. I know we're all facing so many challenges in the wake of COVID-19. Our system in Florida is a little bit different because we are allowed to review an ex parte petition and rule on that without the necessity of a hearing. So we have petitioners file the paperwork, and if it meets the statutory criteria, they are granted an ex parte injunction. However, we still are using the old-fashioned people have to come to the courthouse. We do not have the capability yet to have remote filing for injunctions. So right now, all our intake centers are open. They haven't closed for a second during this, which is great, but it's forced our clerk's office to have to set up furniture to block individuals from coming within 6 feet of them at intake, and also asking petitioners who come in to social distance and use their phones to speak to the clerks whenever possible. We're working right now with our Florida Supreme Court on an access to justice remote filing program. I know other jurisdictions have used it. It's being worked on, and hopefully I think we'll have it up within a few weeks. That will then allow us to have petitioners file for their ex parte injunctions remotely from anywhere. We've already had meetings with advocates and police and other organizations, legal aid, who will then be setting up kiosks to help petitioners fill out the paperwork and also be available for counseling when doing so.
Stephanie, you may be on mute.
Sorry. Thanks, Judge Kelly. We have a question that has come in regarding if a court fails to timely rule on all ex parte petitions and or refuses to have any follow-up hearings to address any economic issues. I know that you are holding follow-up hearings, but so this may be a question better addressed by somebody else, but are there any challenges around the timeliness of these kinds of petitions in your area?
No. So we had previously had in place the ability for judges to remotely rule on all petitions for injunctions. We have a 45-minute rule in our jurisdiction, which means from the time that these are sent to the judge, within 45 minutes, the judge has reviewed and entered the orders. If there is a denial of an ex parte petition, the petitioner is allowed to amend the petition and add additional facts that he or she thinks are important in order to obtain an injunction. And then our hearings are not set in 30 days as in Georgia, but we are set in 15 days. I don't know if that answers the question. And I see another question about where will the kiosks be located. Police station, victim advocacy centers, legal aid, and the shelters for right now.
Thank you. Are there any other challenges you would like to mention about setting up this process? I know it's been a long journey or a quick journey.
No, just that we are not where we want to be yet, but we're working hard to get there.
Great. Thank you. Judge Hilton, thank you again also for joining us today. Did you have remote hearings in place before the pandemic?
We did not have remote hearings in place before the pandemic, and our system was fairly reliant on advocates who were in the courthouse working with petitioners and sort of walking them through the process. And one of the first things that happened, those advocates are from our prosecutor's office, and our prosecutor fairly early on pulled all their people out of the courthouse. And so one of the things that pushed our process was to set up processes for virtual appearances, was that the advocates were no longer going to be able to be there in the courtroom. Our process is not very different from what Judge Anderson described for Georgia or for DeKalb County. We don't have Zoom yet. We're going to, we hope, in the next 5 weeks have Zoom available in all of our courtrooms, but ours is happening by phone. Similar to Florida, the ex parte commissioners can review and decide to grant the emergency order without having a hearing, but we're making it a practice to have the commissioner call the petitioner in any event, so the petitioner knows that the petition has been granted or that it's been denied and there's an opportunity to amend. I guess the only thing I would add that is new is that I think it's really important, if anyone doesn't have it set up yet, and then really even on an ongoing basis for problem solving, to try to get everyone around the table. I think the biggest challenge for us was how to set up a process, and our clerk's office reacted really quickly, but we had a series of phone calls where the victim advocates and the commissioners and the clerk's office and the family law staff were all on the phone to work to just kind of walk through all the steps. And there nevertheless were glitches, and so then we would have another meeting and fix that glitch. And I think it's really important to just kind of get everyone at the table, because we all tend to feel our different pieces of the elephant and not necessarily see the impact on everyone else. And for us, sort of the paper flow, how people could file it with the clerk's office without coming to the courthouse, and then how the clerk would then get it to the ex parte commissioner so that those commissioners knew they needed to rule and get the information to the commissioner about how they contacted the petitioner, and then how you get a law enforcement information sheet, and normally the advocate would then be walking that to the DDPO clerk's office window. So we had to kind of set up all those pieces to happen electronically and without people coming to the courthouse. And I think it's worked out pretty well. We've been probably doing it for 5 or 6 weeks now, but we definitely have had, little glitches along the way. Our victim advocate's office has something called Legal Atoms that they're using to help people file for protection orders through a sort of fill-in process, and they've a couple times not had the new correct order about remote hearings loaded up correctly. So it's just been important to keep talking. I think it's also important to think about processes for people who either can't or don't want to use advocate services. So our advocates will not work with people who have a pending criminal case against them related to domestic violence, and then there are just some people who don't want to use the advocates. And so I think it's important to, unless you have a setup where using the advocates is mandatory, making sure that there's a route in for people who either can't or won't or don't want to use advocacy services.
Great. Thank you, Judge. Let's move on to Amy Hernandez. Thank you for joining us today. Did your court in Utah, so did the Utah courts have remote hearing system in place before the pandemic?
Yeah, we had started remote hearings for criminal cases in 2016, so we hadn't moved to protective orders until this crisis. So it's kind of very similar to my colleagues, kind of a quick move. And there have been some things we've had to adjust, but what we've been doing is our petitioners are able to email the courts directly because we don't have an e-filing platform right now. But what they're able to do is they're able to go on our website, and we have an online court assistance program that asks them questions, and then it auto-populates their form. And because Utah created an Unsigned Declarations Act in 2018, we don't require that the protective orders are notarized. So they can just do an electronic signature, and then they email it off to the court with all of their documents. And we're able to pull that, have our ex parte here, develop the ex parte protective order, and then later on we're able to have the final hearing. And so far we have been pretty productive. We've been using WebEx, and that has been very helpful in how we move forward. And for those that are not able to access WebEx, we have been conducting telephone hearings. And then if worst comes to absolute worst, then they can access the courthouse. But that's proven to be very rare right now. Most people are using the WebEx platform.
Great, thank you. And finally, for temporary emergency orders, Stacy Mars, thank you for joining us. Did your court already have remote hearing system in place before the pandemic?
Yes, in Alaska we have long done hearings remotely in all case types, and that's a product really of our geography, and we're a huge state with many spread out communities from really tiny rural villages to more large urban areas, but most of our communities aren't connected by roads, and so we have not been requiring people to fly in to deal with their court matters from their community, and so we've long used the most simple piece of technology, which is telephones, for people to access the courts, including in domestic violence cases. So it was already in place, which felt like a blessing, because that was one hurdle that when the COVID-19 pandemic hit, that we didn't have to figure out how to get people into hearings. One of the challenges, though, was that similar to Utah, we don't have electronic filing for most of our courts, and most of our cases. We're in a process right now of rolling out electronic filing, but it hasn't been for the domestic violence protective order case type yet. And so it sounds similar to Utah. We have the ability to email the courts directly. You know, we created an email directory for each court location, and then we reprogrammed all of our printers to be able to auto print when the filing comes in, and so you can just see the filing on the printer, and it can be addressed at that time. And similar to Utah as well, if you don't have access to a notary, we have the ability to self-certify a document is signed under penalty of perjury, and so that addressed that issue as well.
Great, thank you. So next we'll move on to final or evidentiary hearings, and we'll start with Judge Kelly. Judge Kelly, you are holding final evidentiary hearings on civil protection orders remotely, correct?
Yes, we are.
What method are you using?
We're using Zoom, and we just started this about 3 weeks ago. So we're brand new at Zoom final hearings.
And so for these hearings, are you accepting evidence other than testimony? And if so, how is the submission of evidence handled?
So yes, we are. When we're setting, first of all, let me back up that we reset all of our cases that were previously scheduled initially for a period of 30 days, extending all the temporary injunctions, and then had to extend it another 30 days when our Supreme Court extended the time for the court shutdown. So now all our notices are going out with a notice of Zoom hearing. And in there, we explain to the parties that if they wish to submit evidence, that we ask them to submit evidence 2 days before by sending it to the judicial assistant. And we strongly encourage that the parties call the judicial assistants, and our judicial assistants have all been trained in Zoom in order to help facilitate the parties submitting documents and other evidence. So they would send it in through a designated email address that has been set up for each judge. And definitely people do have issues with this, so if it doesn't come in, we're dealing with it at the time of the final hearing as best as we can, because this is difficult for many litigants to access Zoom and to use that technology. It's new for all of us, but we understand that there's many barriers that litigants face in using this type of technology for final hearings.
So can you give me an example of how you may have been flexible in the submission of evidence that wasn't handled by early submission, but because obviously with self-represented litigants, you oftentimes do not get that kind of information ahead of time. How have you been able to do that? Handle those in the last minute?
For example, there was a petitioner that had a photo of bruising on her arm and marks on her neck. She had that on her phone. During the hearing, she wanted to present it. She laid the testimony that those were photos that she had taken after the incident, that the respondent had caused those and how he had caused those. And so I allowed her to hold the phone up and do screen share so we could see those, and then made a notation on the record orally that what I'm looking at appears to be bruising on the right arm of the petitioner as well as red marks on the petitioner's neck. And then I asked the respondent, do you have any objection to the way that I characterize that evidence? The respondent said no. And then I asked if there was any objection to that photo being admitted. The respondent said no. And then after the hearing, the petitioner was asked to send that in via email.
Thank you. That's very helpful. So are you making a record of these hearings? And if you are, how are you going about that?
So yes, we invite our digital court reporter to attend, and we've had some issues with that. So they aren't always there on time. They get kicked off. So as a backup, we are always doing a Zoom recording for every hearing and holding those and keeping those. All the judges are keeping their Zoom recordings.
Thank you. Is there any way on Zoom to enable confidential communications between parties and their attorneys if they're represented? And are you using that? Have you used that function?
Sure. So before we set up all of these hearings, we set up breakout rooms. That's a feature on Zoom that allows the host, which is the judge, to be able to send people to breakout rooms where you can have confidential conversations. So before the hearing, we set up usually at least 3 breakout rooms, one for the petitioner and counsel if necessary, one for the respondent and counsel if necessary, and one for a victim advocate if necessary. So anybody that would like to have confidential communications during the hearing, we can send them to the breakout room to discuss whatever they need to discuss.
Thanks. We've had a question from a participant who would like to know about how many hearings you have per day.
Well, that's the big problem. So we were, prior to this, we were scheduling 16, 24, 30 hearings a day. We cannot do this. The time that's involved in these hearings is just absolutely unbelievable how much more time these are taking. So right now, our judges are hearing 4 hearings a day on average. Now, we also have our criminal division up and running, so there's other criminal responsibilities, but four hearings per judge per day.
Hey, that's a really good consideration to keep in mind when moving to this sort of method of holding hearings. What other challenges, if any, have you overcome in doing these final hearings?
Well, I think there's a lot of challenges. Number one, technology, people's access to technology. We know that not everybody has access to technology, and even when they have access to technology, their ability to use it effectively is somewhat diminished. We've had court reporters not showing up on time before. We have tried to deal with victim safety in terms of when we're setting up the hearing, we set up waiting rooms, and then our judicial assistant will invite the petitioner and respondent in individually. This allows them, number one, to rename themselves and hide any email address or phone number that may be associated with them calling in or connecting via the internet. And we also discuss about changing their background so that if they would be in a place that may disclose their location, the JA discusses with them how to put up a virtual background or to move to a location where perhaps nothing would disclose their location. So that safety feature has been a challenge. We have had lots of issues with interpreters and translation. So in Miami-Dade County, we have a large percentage of our population that speaks another language, and when we have our interpreters present, they can no longer do simultaneous interpretation. It has to be consecutive. That really, really lengthens the times of these hearings. If we have voluminous exhibits, we usually have to reset those cases because it's very difficult for the court to screen share or the parties to screen share and effectively go through their exhibits. And this is particularly true in cases of pro se self-represented litigants. The pro se's understanding of Zoom and how to effectively utilize it is a challenge. Swearing people in is a challenge. If they're calling in, how do we identify who they are to ensure, that they are who they say they are? Phone appearances are always challenging because we're not able to see the parties to judge credibility and to, make certain findings. Credibility is very difficult, I believe, over these platforms. Ensuring procedural due process is really important too. Can people hear and see us, and can we see and hear them? And that's just one part of it. We've had litigants being coached. So there was a hearing that I attended where another judge was handling it, and the respondent was being told what to say by another individual, and we could all hear the other individual telling the respondent what to say. And the judge had to ask, who's there talking to you? And we understand that that's a big problem with these hearings, enforcing sequestration, and how do people, even if they live in small homes, how do they sequester themselves from other potential witnesses without tainting the record? And we've had connectivity issues. So we've had a lot of issues that we try to overcome, but I can't say that it's been a few. There's a lot.
We have one question for you. Thank you for giving us all that great information. We have one question, and that's about, you mentioned a little bit about interpreters, but have interpreters been readily available? Have you had issues?
Yes.
Yes.
No, we have interpreters available, and when the parties call in, the judicial assistant inquires as to whether any interpretation services are needed. We try to find that out beforehand by having the assistants call, but we haven't had an issue with interpreters being present. The issue has really been the length of time and the ability to interpret in a timely way. It really, really lengthened the proceeding.
Great, thank you. We'll move on to Judge Helson. You're also doing final evidentiary hearings remotely, correct?
We are, and I think we have experienced many of the same challenges. The issue of everything taking longer is a huge challenge. We, frankly, were woefully and still are woefully ill-equipped in terms of the ability. We're not doing Zoom hearings. Ours are all happening on the phone. I think when people have new information they need to present, it often means it has to be set over. We're doing it on the phone in a way that requires us to call the people. And so one of the things that takes a long period of time is parties and lawyers not answering their phone. Lots of groovy hold music that you get to listen to for extended periods of time. One of the other issues for us, I don't know that it comes up so much in the ex parte hearings, but it definitely in the full hearings and in the weapons compliance that I'll be talking about in a little bit, is Washington has a really strong doctrine of open courts. And so one of the things we have to do at the outset of every calendar is make some very detailed findings. We call it Bone Club because our leading Supreme Court case is State versus Bone Club, but we have to make findings that there's a compelling basis to engage in a partial closure of the courtroom, which is effectively what we're doing when we require everything to happen by phone, and that there's no lesser means for doing that. And we also have to give everyone in the courtroom and on the phone an opportunity to object. Now, no one in the context of DVPOs has objected so far. If they do object, you can still go about making your findings, but that's something that also takes some additional time. There's a pretty long kind of colloquy set of findings you need to make at the outset of the calendar, and then for every new person I do an abbreviated one and give them a chance to object as well. So that's one of the pieces that happens, but really things do take an extraordinarily lot longer, particularly if there are things like interpretation to be addressed. We're really looking forward to having Zoom technology in another 4 or 5 weeks, but it's been challenging to be doing it just on the phone.
And about how many hearings would you say you've approximately been doing a day?
So what we've been doing in a morning calendar, so one of our other challenges is that in order to kind of create equity among staff and judges and commissioners, normally our domestic violence protection order calendars have been covered by our family court commissioners, and our family law staff are in the courtroom with them. Early on, when we still had people coming to the courtroom, and then when we had them coming to the courtroom, even though we were telling them not to come to the courtroom, we really felt like there needed to be equity in terms of who was having to come to the courthouse. And so all of my unified family court judges have been rotating through there. So one of our additional challenges is we had to do training to just make sure the judges understood. They knew the substantive law since they entered protection orders as part of family law cases, but they didn't know a lot of the mechanics about being on the calendar. And so all of that being said, we have between 2 and 3 courtrooms in each of our courthouse locations, but we really have decided you can't do any more than 6 hearings in a morning. And, you know, that frankly generally assumes that 2 or 3 of them are going to be reissuances and not be substantive hearings. You really can't do more than, I don't know, a couple of substantive hearings. The morning I sat, I had a Mandarin translated hearing, and that by itself took most of my morning. So it is really slow going.
Thank you. Thank you for sharing all that helpful information. We will now go to Amy Hernandez. Amy, Utah has started using remote for civil protection order hearings, correct?
Yes, we are using the same WebEx to have the final evidentiary hearings. And most of our litigants, pro se, and then those that have attorneys, are just emailing the evidence in. So that's how we've been able to accept it. And then we, unlike some of the other states, we actually broke away with the old school court recorders, the court reporters. That we had to do away with that during the 2008 recession. And so we have switched to a platform where we just automatically record the court hearings. We've been able to do that with WebEx. So we have 2 copies of the record. We have one with WebEx, and then we've got one with our platform just in case, because sometimes glitches happen. But that's what we've primarily focused on.
Great. And how many hearings have you been able to do in a given day?
So we, similar to the other courts, we have dropped off. We I just pulled my data. In January, we had about 1,500 hearing or protective orders that went out, and we've dropped to about 1,000. So we have slowed down significantly, and it's the same issues. Interpreters, we can't simultaneously interpret. We're having to consecutively interpret. And then just access, explaining how to use WebEx to our pro se litigants, how to, if they can't use WebEx, we have to go through the telephone, and it takes quite a bit of time as compared to the in-court hearings. So that's kind of been our very similar barriers to Georgia, Florida, and Seattle.
Thank you. Moving on to Stacey Mars, you also are doing final hearings and civil protection orders remotely, correct? By phone?
Yeah, that's right. We are. Yes, some of the things that were said previously are true in Alaska as well. Each of our courtrooms has an 800 number associated with it across the state. So when the case is set for the long-term hearing, the parties in both cases are given the 800 number and the access code for that particular courtroom where their case will be heard. And so they're supposed to call in to the hearing at the appropriate time. Similar to some of what we've been hearing, when evidence that hasn't been previously filed needs to come in, like in real time, somebody realizes they want to share that piece of evidence, that's been done by email or even text into the courtroom. So they'll just give them the way to connect right at that time, and then the person will send that in and it'll be reviewed right at that time. Like Utah, we also do digital audio recording. We don't have court reporters, so when somebody calls into the hearing, it's just recorded right into the system. The phone system is connected to the recording system, and then within the courtroom we have a speaker system, so everything that's on the record is broadcast into the courtroom. So that's how those issues are addressed. And we have seen a drop in the number of our protective order hearings, but actually not as big of a drop in all of our other case types, which have a significant drop. Since fairly early in March, we have, as a priority hearing, domestic violence cases were continued to be heard. So we've had a decrease, but not a massive decrease rather. And then in terms of the use of interpreters, we use telephonic interpreters as well, and so that, like others have mentioned, involves consecutive interpreting and not simultaneous. So that does take a bit longer for the interpreting cases, but they routinely happen. And I would say in our larger courts, we're still doing, within a hearing block, up to probably 15 protective order cases still with, telephonic hearings occurring.
Great, thank you. I do have one question for you. With the 1-800 number, does the judicial officer have any control over who comes in to speak in the courtroom?
No, although we have the ability to mute everybody but the speaker, but it's kind of like an open hearing, like anybody can call into the conference line. So our protective order hearings are generally in larger courts or block hearings where there may be several cases all scheduled at the same time. And so people just kind of wait their turn, and then when they're called, the judge will, say their name, and then those parties participate at that time.
Great, thank you. And a follow-up question about emailing exhibits. Are those exhibits going to your court email, and how is one making sure that all of the exhibits are received and given together?
Well, we have instructions on our website, and our self-help center and our customer service folks across the state would share this if somebody called in with a question about how the protocol basically for emailing documents into court in advance, and how that should work, and what we have some samples of what the email should look like and what the subject line should say and things like that. If it's done during a hearing, that's kind of more on the fly, and so that would be directly to the email address of the in-court clerk who is helping the judge in the courtroom, and then that person just gets the evidence right there and would either email it to the judge or print it out right on the spot, and then it would go as part of the record.
Great, thank you. So we're going to move on now to compliance monitoring, and we're going to start with Judge Hilton. Judge Hilton, you are conducting compliance hearings remotely. What type of compliance hearings are you holding?
So I am hearing weapons surrender compliance hearings, which are actually the only kind of compliance hearings that we've been doing up to now. I think we probably should be adding other kinds of hearings, but I'm not sure now in the time of COVID is time to do that. So we have a firearms weapons surrender calendar. It happens once a week. And again, really, one of the things that sort of moved us towards, but we would have been for public health reasons anyway, but one of the very helpful resources we have is that our prosecutor's office domestic violence unit appears as a friend of the court on that calendar and provides information about whether people have a firearms purchase or pawn history or concealed pistol license. And really having that information is what allows it to be a much more informed discussion about what firearms someone might have that should be surrendered. Very early on, they were not able to be in the courtroom in person anymore, and so what we did at first was have them on the phone and kind of practice social distancing and have people wait outside. That was probably 6 or 7 or 8 weeks ago. That was quite a long time ago. Then we moved to having it be by phone only. We changed the forms so that people were directed to contact weapons-surrender at kingcounty.gov or to call a number that's actually my bailiff's number the day before. It still took, for several weeks, we still had some number of people come up. It was a small enough number of people that I could pretty effectively distance them in the courtroom and have them not come anywhere near my staff and have them drop things on the table and back up. But for the last 3 or 4 weeks, it's been all telephone. And last week, we finally had sort of a similar attendance to what we had had previously. We had a lot of people call in. We're doing it all by phone. I think one of the obvious challenges of the phone is I think it's much harder to determine credibility when you can't see someone. For purposes of compliance, I think you have less ability to influence someone when they're just a voice on a phone line. I will say that I think in part the people who show up for weapons compliance are not entirely, but a fair number of them are people who are trying to comply, and so a lot of them are motivated to be found to be in compliance. You know, what frequently happens on the calendar, whether they're in person or on the phone, is that they'll show up, they'll have signed their declaration of non-surrender or provide their proof that they've surrendered firearms, and I'll point out that really we have a record that they own 5 other firearms. Where are those and what is the proof of where they are? And so we often have a sequential hearing process. I feel like they're less likely to re-engage and provide the additional information now that it's by phone. Some of them still are, but others, I think, you know, when it doesn't tidily go away, are less inclined to re-engage than they would have been if they had been there in person. For the compliance hearings, I also have to do the open courts discussion at the beginning and find that there's a basis to be having a partial closure. There's a lot of communication that my bailiff has to handle in advance. The information the prosecutor gives me, my bailiff sends emails out to people who've arranged to appear on the calendar, so that normally that gets handed to them in the courtroom, and part of it is a certain element of surprise, so they can't, you know, have figured out whatever it is they're going to say. There they are in the courtroom getting the information about, yes, we know you bought those 10 firearms, and so they're now getting it sort of the end of the day before, and that there's really not a way around that, but they're not getting it very far in advance. And I do a number of cases the day before where there is no information related to firearms. There are no firearms allegations, and if they've filed a declaration of non-surrender, I will just find them in compliance based on the paper review and excuse their appearance. And then I normally start with the firearms negative cases, and often that means we're emailing them out a declaration of non-surrender if they haven't already filled one out, and putting them back at the end of the calendar if they have the ability to get it back to us. There are a lot of logistical issues. People can't go to libraries to use computers anymore. Not everyone can scan a document. Not everyone can email in. So some of them are still dropping things off at the courthouse. The courthouse is pretty empty, so it's a fairly safe thing, I think, for them to go into the clerk's office and drop it through the slot, and it just may mean that they have to come back on the phone a couple weeks later. We've been pretty relaxed about letting people email if they can't e-file, so a lot gets emailed to my bailiff and she handles filing it. I think, you know, as everyone else has said, I think it's hard to address credibility on the phone. We're looking forward to having Zoom available to do this in 4 or 5 weeks, and that's kind of what we've got. I actually think that calendar is running fairly efficiently and fairly well, but it's taken a number of weeks. We have a lot of information for respondents that is provided to them at every step of the way. So when they get the order to surrender without notice, they get some directions. When they get a full order, they get some directions. Every one of my orders gives them directions about how to call in, and I think we're finally hitting the place where people are figuring it out and we're having higher numbers.
Great, thank you. That's all great information. We do have a question for you specific to compliance monitoring. The question is, what does the prosecutor do during these hearings? Do they make recommendations, help to monitor compliance, or report to court later? What's their role?
So one of the things they do that is often helpful is they often have had time to go through in more detail than I have, particularly with people who have, you know, a history of purchasing 15 firearms, and they have these receipts for this and this receipt for that, and 4 were seized by law enforcement 5 years ago. So often they'll kind of connect those dots and say, you know, Your Honor, I think that we think we've accounted for 8 of the 15 firearms, and here are the 7 that we don't know about, and then the respondent will talk about, you know, what happened to those firearms. The prosecutor does make some recommendations in terms of saying, you know, stating their opinion about they don't think they're in compliance, or they think there are unanswered questions about this, that, or the other. Sometimes it turns out that the petitioner may have information about the firearms, and so the prosecutor agrees to circle back to the petitioner through the victim advocate to see if, yes, in fact, those are the petitioner's firearms, or those are still in the gun safe in the home that the petitioner is occupying and can be turned over to law enforcement. So then they also can be helpful in terms of gathering additional information. So, you know, we'll hear that, oh, that firearm was seized by such and such police officer in an arrest 3 years ago, and I'll reset the hearing, and the prosecutor will go out and see if they can gather that information and confirm that that's correct.
Great, thanks. So we are also going to ask Judge Kelly about compliance monitoring. Judge Kelly, have you started using compliance monitoring remotely?
Well, we're having our first calendars next week is the plan for that. But we do our firearm compliance at the time that the petition is served on the respondent. The respondent is given a notice and an affidavit that he or she must fill out regarding their firearms and in order to surrender their firearms to a local law enforcement agency, and to immediately send proof of that surrender to the court prior to the hearing. So if we get to the final hearing and we don't have that proof of surrender, we give them another 24 hours to have those firearms surrendered and a receipt sent to the court. If not, they're subject to contempt charges. So the challenges we're having right now is we definitely have people that think that they do not have to comply with portions of the court order because of the pandemic. So our next week calendar, we're going to be setting people that we have their email addresses that we know are in non-compliance. So that will be the first calendar, because it's just quite honestly very easy to get the notice to those individuals. And we can give you more information on how it goes, but we're hoping that some of the issues with noncompliance with batterer's intervention program, for instance, would be that they didn't know that the batterer's intervention programs are still up and running remotely. And so we're hoping to get people back into the classes and at least let them know that we are watching and we are maintaining an eye on them, and we are going to be enforcing compliance with the terms of the order.
Great, thanks, Judge. We will now move on to issues specific around domestic violence and access to justice regarding remote hearings. And for this segment, we will start with Amy Hernandez. Amy, civil protection order cases often involve self-represented litigants. What steps has the court taken to ensure litigants can access these remote hearings?
So we have partnered heavily with our networks across Utah. We, similar to the other speakers, we held a roundtable and we worked out some of the kinks between the victim advocates, between attorneys, legal aid, and our defense attorneys too, because sometimes they'll be involved in the civil protective order process. So we brought them all together to make sure that they all had access. And especially for our pro se litigants. So if we have somebody, like I said earlier, that cannot access the courts due to if they don't have internet, or for some of these populations, they're just an at-risk population for COVID, we have partnered with the victim advocates, so they're able to call a number with legal aid that covers the entire state of Utah. That legal aid person will then connect them with a local victim advocate, and where possible, the victim advocate is able to go out to their home or help them with the protective order forms and help them fill it out and get it submitted, and that's submitted on the victim advocate's email address. In some cases, there may not be a local victim advocate that's close by, or this person may have actually tested positive for corona, and so some of our service providers have been able to take stuff over the phone, our legal aid, and they've been able to kind of swing things a little bit. We've also opened up our law library. In the past, we did not take information over the phone or to help people fill out protective orders. It had to be done in person. With our law library, and we recognized some of the challenges for our pro se litigants, they can now call into our law library anywhere from the state and get help filling out that protective order form. We can't give legal advice, but they just help them fill out the base protective order form and get it sent off so it can be emailed. If they don't have anything like the Wi-Fi or call minutes, if they have nothing, then they still can come into our courts and we will help them. But that has proven to be very rare. We've only had 3 or 4 across our entire state that have had to use that measure. So we've been tracking that very closely, and we feel pretty confident that our pro se litigants have access to the courts, and we have kind of a more open court system right now.
Great. And do you have any sort of tip sheets or summaries for self-represented litigants on how the process works remotely?
So right now we do not. Our court clerks have been walking litigants through the process step by step, and they email them the instructions as they go through. We're developing a WebEx instruction sheet and then a telephone instruction sheet to kind of help guide them. We do have instructions on how to use our online court assistance program that helps auto-populate the protective order. That was in place before Corona, but we are working on a tip sheet so they can access the hearings. And then for those that need interpreters or have different access issues, how to access the courts in that way. That has already been established, and we just want to include that on our tip sheet into the future.
No, that's great. That's great. And your, if I remember correctly, your Utah website, Utah Court's website has a pretty good set of explanations for pro se litigants on how to file remotely through email. So is that correct, right?
Yeah, we have step-by-step, and then it has been reviewed by our victim advocates, by our defense attorneys, just to make sure that everyone has access. And it's constantly being updated to make sure that it's easy to understand and that everyone can have access to the courts.
Awesome. That's great. Before we go to the domestic violence specific question, I think I'll go ahead and ask other participants or other panelists about these access to justice issues, and I'll come back to you, Amy, okay?
Okay.
So, Stacey Mars, how has Alaska dealt with self-represented litigants and ensuring litigants access to remote hearings?
In many of our cases, people are representing themselves, and there are no lawyers at all involved. So it's always been a priority case type for us to really think carefully about and do a lot of outreach work to make sure that people who are seeking domestic violence services and assistance through our domestic violence network across the state know about what the court offers and is able to help kind of extend the information beyond just the courts. But our self-help center has always spent quite a bit of time providing information, and then online on the court's website and the COVID response page, we have specific information that's related to the changes in the operations due to the pandemic. So there's the important information to get out to the public, but I think there's also important access considerations for how the hearings are conducted in the court, particularly when they're remote. And when you have people on the phone, you lose the body language and the nonverbal cues that are really important parts of communication. So I think there's some extra steps that the judicial officer really needs to be mindful of in conducting hearings, particularly by phone. And that's to, when you start out the process, to make sure to give the parties and everybody involved essentially a roadmap of what to expect at that hearing, and make it very clear that everybody is going to get their chance to speak and that there's a specific order to the way the hearing works, and the judge will let everybody know when it's their turn to speak, and so that avoids people talking over each other, and that there shouldn't be any interruptions because everybody's going to get an opportunity to say what they think is important. And then throughout, it's also important for the judicial officer to solicit understanding from the people on the phone, because you can't observe them to know whether or not you're getting it. And so that's saying things like, in your own words, please tell me what you understand that I just said. And also giving opportunities to ask questions throughout so that everybody feels like they had the opportunity to participate, that they were listened to, and all the important things about procedural fairness. So I think it's important to make sure that just because you're providing access, that you also make sure during the process that people are having meaningful access to the process while it's happening.
That's fantastic. Thank you. Moving on to Judge Anderson. Judge Anderson, do you have anything else to add? Any other challenges? Any other steps the court has taken around access to justice?
When we initially sat down and created a roadmap for what this virtual hearing process was like, it was really important, to the extent possible, that we mirror what we were doing in face-to-face hearings. And so by way of providing information to litigants about what information they want to bring to the hearing or have prepared for the hearing, we make sure that they get that information and they're getting it remotely. Advocates are involved early in the process, and we have found that to be incredibly helpful in getting the messaging out the message, we wanted the message to be not that the courts are closed, but we're still doing business as usual. We utilize our local television station to, they usually do a bit of a ticker tape around the bottom of the television screen to let them know that if you're a victim and you need assistance with a protective order, this is who you contact. And it's just really important that pro se litigants get that information, because the majority of the cases that we hear, we have self-represented litigants, and attorneys are in a smaller number of the cases. But it is important that whatever message that we give or whatever instructions, that they're consistent, and that was consistent in all press releases, consistent with any postings outside the courthouse, consistent with messaging to some of the free newspapers that are throughout the county. So we wanted to have a consistent message. Also, if you reached out to the clerk's office or any of the advocacy agencies, that the messaging is the same.
Great, thank you. Judge Kelly, anything else to add?
No, I think that my colleagues have covered it. Thank you.
Judge Helson, anything else that your court's doing, or is that also covered? Well, it's covered a lot of ground, so, but yeah, anything else your court's doing?
I think it's, I think pretty similar. I do think it's important to constantly be reevaluating, updating your website, updating the materials that you're sending out to people, being available to hear about glitches or things that didn't work or things that might require more explanation, so that you're kind of constantly fine-tuning and updating the information that's available to pro ses, and also sending it out affirmatively to your community contacts. Consider tweeting it out. Consider, you know, making sure that when you update something, it goes out to the legal services programs and the advocates and the defense bar who's involved. So the communications piece, I think, is tricky and something we're constantly working to improve.
Thanks, Judge. That's a great point. We will now move on to the domestic violence portion of the remote hearing safety considerations. And I'll begin again with Amy. Amy Hernandez, a lot of safety concerns that arise for in-person hearings where the victim and abuser are in the same room are not necessarily present in remote hearings, but other safety concerns may be. For example, accounts used to communicate with or access the court through technology may be compromised by the abuser. Backgrounds visible behind the victim while on screen and knowingly may give a location or other information to the abuser. Or a child may inadvertently come within a hearing or even on screen while the parent is testifying about abuse. That's just a couple of examples. Has the court taken any particular steps to address these types of issues, such as providing access to any resources or referrals around safety planning for remote hearings?
Yes. So before the outbreak, we had a general safety plan on our court's website, and we've heavily partnered with our victim advocates to make sure that they're providing a safety plan as people access it. We've been tracking with our victim advocates to see, are any of our pro se litigants, do they have unsafe email addresses or compromised technology platforms? And so far, for those that do, we've been able to connect them with the victim advocate, and then we've also been able to connect them with our Utah Domestic Violence Coalition, who has some grants for technology aid and can help educate petitioners about some of the tech aspects so they can reclaim that email address down the road, which has been helpful. We actually are going to next week meet with victim advocates across the state virtually and help them fine-tune their safety plan for protective orders, for the civil protective order process, and make sure that everyone has a safe email or safe call-in number. And so far, it's proven very successful. We haven't had any issues, to my knowledge, that have popped up. As far as if somebody walks into the room. I believe Florida brought up when sometimes people will walk into the room. That has proven very difficult for our judges to control, given everything's such tight quarters. We are asking people to go to another room, put headphones on so that kids can't hear what's being said back and forth. But that's not always within our control, but we do try. And we do try to educate victim advocates about letting their clients know and pro se litigants, hey, your background can be seen from WebEx. You can, you need to be aware of where you're at as you're accessing this hearing. So that has proven very fruitful and helpful.
Great, thank you. Are there any other safety concerns that you've come across with remote hearings yet, or anything that that maybe others haven't thought of or you hadn't thought of until it happened, anything along those lines?
We have been concerned with tampering with the witness. Before, for example, we had a case where an elderly woman filed for a protective order against her grandson who was living in the same apartment. And we later discovered that the grandson was threatening her and trying to remove it. And I know that occurs with civil proceedings, but in the past, we probably could have banded with our victim advocates to move her to shelter. It could have been handled a little bit differently, but she was so terrified of corona because she was such an at-risk individual with health complications that she ended up dropping her protective order. And so that has been a big barrier for us, making sure that if we do have people that live in this, that have the same living quarters, that they're not being tampered with. And that just has proven very tricky.
That's a great point. Yeah, definitely. I know that that happens without remote, but when they're not in the courtroom, it's harder to even monitor if they are being harassed or coerced in any way during the actual hearing. So that's a great point. Thank you. Moving on, Stacey, anything to add around what the court's doing to address any safety issues, any resources or referrals?
Well, it's interesting because one of the safety things that we're doing is we're actually allowing people to come to the court if they need to. So we don't have a hard restriction against coming to the court. In the past, our use of telephonic hearings was an option if that made the most sense for somebody for different, logistical reasons. It was hard to get to the court, or they had work issues or childcare issues. And now we have switched to highly encourage, like, please don't come to the court if you can avoid coming, because we are trying to keep people out generally for health, safety concerns. But we've made it clear that if it's the safest thing for you to actually come to the court, either to file in person or to participate in your hearing in person, you're clearly welcome to do that. So we've, in terms of our physical access, we've allowed that really as a safety option. But we have, and we do allow people to come as support, but we've limited the number of support people that physically can come because we don't want excess people waiting around and impacting the potential for really having social distancing going on. So when I think about safety, it's more allowing people to our courts, but we've also, we're always in good contact with our advocate community, and we have a regular meeting with all the advocates, which is continued or representative of the advocates in the legal community every other month, and our self-help program is the liaison with the advocate community, and so keep in touch with them to make sure that we have a good understanding of what services they're offering during the pandemic and how to make sure that we can make appropriate referrals that are accurate when some of their services have changed as well during the pandemic.
Great. Thank you so much, Stacey. Those are also wonderful points. Judge Anderson, anything you'd like to add around safety, resources, and referrals for remote hearings?
No, I think it's just important, again, going back to the beginning of the process, to make sure that victims are aware that if there is someone who has access either to their cell phone or their computer or their email address, that it may compromise their safety. And if they have concerns about that, then they need to reach out to an advocacy agency to figure out another way that the court can get them the protection that they need. It may be that they do have to come in person and have a hearing in person instead of virtually. But we'll figure it out and try to make sure that we can get them what they need.
And you have that on your website, correct? On your protection order website? That
Yes.
sort of information?
Yes.
Perfect.
Absolutely. And we want them to be safe first. It's in big, bold letters.
Awesome. Thank you. Judge Kelly, anything else?
Just one thing, that during these hearings, typically in person, we bring the petitioner in first, sit the petitioner at a separate table, then bring the respondent in. And what I've noticed during these hearings remotely is that both parties are facing each other, and that can really cause a lot of trauma to a petitioner. And so at the beginning, we really lay out in the colloquy about no facial expressions, no emotional outbursts will be permitted, no type of harassment will be permitted during the hearing. It is pretty hard for, I think, for the litigants be facing each other in these hearings. Even though they're not face-to-face, there's still that trauma that, that rises up when virtually facing a person who has abused you. So we make our instructions very clear at the beginning about that.
That's great. That's a great point as well. Yes, setting out up front what the expectations are and what will happen if they are not met, et cetera. That's fantastic information as well. Judge Hilton, anything to add about how your court is addressing safety or any other noted safety concerns with remote hearings that have come up in your work with the remote hearings?
I think people have covered it really well, and since we're not Zooming yet, it is helpful to hear all the things that people are thinking about. So I appreciate having all of that information before we get started on Zoom.
Great. Thank you. So we'll move on then to our final segment, and that's on the future of remote hearings. And for this one, we'll start with Stacey Morris. Alaska, as you mentioned, has been doing remote hearings for quite some time. But how has the pandemic changed the way you have facilitated remote hearings?
The biggest change is that we had not accepted the underlying request for the hearing by email before. That was largely a paper process. In some communities, there was emailing or faxing in the documents. And so that's probably the biggest change, is that we very quickly figured out that we needed something different that would work. So we may keep something similar while we're getting our real kind of electronic filing system up to speed. So that kind of remains to be seen if that'll stick around. But the other thing that we are working on, depending on the community right now, is introduction of some online video platforms. We can't do that everywhere in Alaska because we have limited bandwidth, and not all of our communities even have cell phones with data plans, so it's pretty widespread. We only have talk only in a lot of our communities, and since cell phones are such a primary way that people communicate, and many people don't have their own computers in their homes, we will continue for sure with telephonic hearings for the near term until the physical infrastructure in Alaska changes to have more bandwidth for internet. But we may, in some of our larger communities, introduce things like a Zoom hearing, which we're working on right now.
Great, thank you. Can you also tell me what stakeholders are important to engage with and when you're developing or implementing and evaluating remote hearing processes and policies for civil protection orders?
Yeah, the the domestic violence community is obviously really important. So the shelter community advocates, the lawyers that do representation in those cases are all really important. We have court-based advocates in some of our locations, and they're really important stakeholders because they're often seeing a different population than the shelters see, because as we all know that some survivors will never go to a domestic violence program, and they may only go to a court. And so if you can engage the services of those programs from a court location, then you open up the possibility of being able to serve more folks. And so those people have very important insights because they may be seeing a different population than the shelter population. So I think all of those different stakeholders are really important. The law enforcement community is really important. In Alaska, the law enforcement on the local level as well as the state troopers serve our protective orders, and so they engage with the respondents and as well as the survivors. So it's important also to hear their voices in what can work in these processes.
Great, thank you so much, Stacey. I will now ask people who have not had a long history of remote hearings in their civil protection order process. Judge Anderson, we'll start with you. Will you consider keeping remote hearings as an option after the pandemic?
Absolutely. Our judges are so excited to be in a position so that they can handle these hearings from their homes. I am having conversations right now with our IT personnel about expanding and getting us access so that we can increase access to the courtroom. You know, Georgia has a requirement that our courtrooms have to be open. And so our courtrooms have been open to the public, but we want to take a look at other technology, I think YouTube or some other technology that's out there so that we can include the public in on these hearings. Obviously, we want to do it in a way that's safe for everybody that's involved. But we are super excited about the possibility of keeping these hearings. I don't think that we can get to the point where we can do all of them remotely, but I'm excited about keeping a portion of our hearings remote because it really is an access to justice issue for those litigants who have difficulty getting to the courthouse or child care issues or just terrified about coming into the courthouse. So yes, I absolutely look forward to increasing and expanding what we're doing.
Great. Also, I know you mentioned that you worked with advocates right at the front end of this to bring them on board and to discuss how to best do this. Are there any other stakeholders that are important for you to engage with in developing, implementing, or evaluating the remote hearing process moving forward?
Well, yes. So it was our clerk of court, where the process begins. So our clerk of court, obviously our sheriff's domestic violence unit, they're the ones who are charged with serving the protective orders. They're also charged with seizing any weapons that are been ordered to be seized. It's also helpful to have advocates at the table and make sure that they're culturally specific advocates. Probably some of the FVIP providers. I understand in our community we have more than 20 FVIP providers, and I know they call them VIP providers in some other jurisdictions, but most of them have gotten on board and are conducting their classes remotely. Obviously the information technology people and anyone else, the volunteer lawyers who handle these cases. It's important to have as many people at the table as possible and to develop relationships before you find yourself in a situation like this COVID-19 pandemic. These are long-standing relationships that we've had. So it was very easy to pick up the phone to say, help. You know, we need to get up and running virtually, and we were able to do that.
Perfect. Thank you. Judge Kelly, how about you? Is your court considering keeping remote hearings as an option after the pandemic?
I hope not. You know, I think on a case-to-case basis, but personally, I don't think there's any substitute for face-to-face testimony and judging credibility and allowing people to tell their story. We're going to keep it going. It's kind of like keeping a couple balls up in the air. I believe if we can implement our remote filings, that will be wonderful using the Access to Justice application. I think that will be a great advantage for our jurisdiction. We started our criminal hearings, our first appearance hearings, and other arraignments and things will be held remotely. We may be able to do that, but we're struggling. All our judges are struggling. We cannot possibly handle the number of cases that we have with the number of cases we can effectively hear per day. So we are falling far behind every single day in the number of people that need hearings. And I'm quite honestly, I'm not sure how we're going to get ahead of it. But I think we're all very much looking forward to the courts opening again and allowing people to come in and have their day in court. I'm not of this technology in this type of case. In other cases, or perhaps where both sides are represented by counsel and they're tech savvy, that's wonderful. But I think there's a lot of reasons not to totally embrace it in our jurisdiction.
Thanks, Judge. Judge Helson, how about you? Will you consider keeping remote hearings as an option after the pandemic?
You know, our statute requires that petitioners have the option to appear by phone for safety reasons, and we've always allowed out-of-state respondents, for example, to appear by phone. I think what it's going to allow us to do is a better job of the cases where there is a compelling reason to do it by phone. I think and hope that on the emergency order front end thing where I don't think it's as cumbersome, I hope we will be thinking about how to do it in a more access-friendly way using remote services. I know Massachusetts for years, people can walk into a police station 24 hours a day and get a protection order, and I would like us to think about whether there are ways that will make it easier for petitioners to access the front end. But in terms of full hearings, I share a number of Judge Kelly's concerns. I think it was Judge Kelly who was speaking about kind of the quality of decision making and how the process works and our ability to handle the volume. So I think what I hope we'll be doing is doing a better job of the pieces where there is a compelling reason to do full hearings remotely, and that maybe we'll use the remote part to look at the front end, where I think the time constraints are different, and there could be some benefit to keeping it in place.
Thanks, Judge Helson. Amy Hernandez, how about you in the Utah court? Are you considering keeping remote hearings as an option after the pandemic?
Yeah, we are considering it. We're thinking about kind of a quasi, one person could come into court and the other person could be at home, or kind of what was earlier mentioned in highly lethal situations, or when you have an out-of-state respondent. We would have to make some rule changes, things like what happens when you do have somebody who's trying to coach somebody over the phone. We probably would have to scrap that hearing and have a new hearing. We'd have to kind of build some more infrastructure before we could completely continue. But I estimate, at least in Utah, I don't know about the rest of the nation, we are thinking that through the fall and winter of this year, we probably will just have to do remote hearings. So we're pouring everything that we've got into it. So I do anticipate that we will continue this way for the future.
Great. Thank you so much. And thank you all for joining us today. We have hit the out-of-time marker. We will be sending out some of the tools and resources mentioned by the panelists in a follow-up email, and we'll also include them with a recording of this webinar on our project webpage, civilprotectionorders.org, which you can find right there on the screen. We also have resources available on our other projects and on responses to COVID-19 on the National Council of Juvenile and Family Court Judges website at ncjfcj.org. If you have any questions you would like to ask the panelists or our team, or any questions that we were not able to get to today, please feel free to reach out to me, Stephanie Bowman. My email address is on the slide, sbowman, S-B-O-W-M-A-N, @ncjfcj.org. And again, thank you all for joining us, and a special thanks to our panelists who took time out of their busy schedules to talk to us about their journey, challenges, and successes with remote civil protection order hearings. I hope everyone has a great rest of your day. Thank you.